you done? You got an opening statement?
I was told to keep it brief, so that's what I tried to do, Chairman.
Okay, then we will go to questions. You've obtained clerkships. It's an impressive accomplishment for a young lawyer to be before Supreme Court clerkships. It's a mark of great academic distinction. It seems to me, without knowing all the history of clerks, that you're kind of in a category all by yourself, having clerked for 3 sitting Supreme Court justices, 1/3 of the court. What lessons from your clerkship will you take to the bench if confirmed as a circuit judge?
Clerking for the distinguished jurist for whom I clerked was a tremendous honor, something I never anticipated I have the privilege of doing. I learned, Chairman, the importance of the judicial process. We have a deliberative judicial process and an adversarial system for a reason. We receive briefing, we hear argument from the parties, the jurists discuss issues with their colleagues, and through that process, the correct rule of law emerges, and that is what is to be followed, and that might sometimes diverge from how you originally thought a case might come out. So the importance of the process is one thing I learned. Of course, I had exposure at all 3 levels of the federal judiciary to a tremendous volume and array of types of legal matters, from sentencing hearing revocations to the most meaningful constitutional questions at the Supreme Court of our generation. So I learned that each case, no matter its importance to the nation, is important to the parties and should be treated with respect and care. And finally, I learned that you can go through that process and issue the correct rule of law. And in our system, people might not always agree with the decisions that courts hand down. And it's important to understand that in our system, decisions will not always be popular, and that it takes grit and courage and determination to carry out your Article III obligation under the Constitution. And so those are things I witnessed in the jurist for whom I clerked, and I would try to take with me to the bench.
You've also practiced law at a highly regarded law firm, and you've led litigation for the state of Tennessee and some of our country's most important recent cases. Nevertheless, some progressive organizations have suggested that you lack the requisite experience to be a circuit judge. So can you tell us how many cases you've served as counsel for a party or as an amicus?
My best estimate is I've served as counsel in probably about 80 to 90 cases, distinct matters ranging from state court, federal court, primarily practiced in the federal courts of appeals and federal district court. And so I think recently the cases have come fast and furiously, and I've been privileged to handle a number of nationally significant matters on behalf of my home state of Tennessee, as well as many other states.
Have your experience as a lawyer for the state of Tennessee and on behalf of private clients prepared you to be a judge of the Sixth Circuit?
I would hope they have, Chairman. Again, I've represented clients at the law firm of all types, from individual criminal defendants to asylum seekers to businesses to Fortune 100 companies to mom and pop stores. In my current role as director of the Strategic Litigation Unit, I've recruited 7 to 8 attorneys into our office to litigate some of the nation's most significant and complex constitutional, statutory, and administrative procedure matters on behalf of Tennesseans. And through that experience, I have extensive knowledge of the federal court system and of how to approach many of the legal issues that would come before me if I were so fortunate as to be confirmed to the Sixth Circuit.
My last question is, please describe what judicial independence means to you.
So to me, judicial independence goes to the heart of the structure of our constitutional system. The founders set up 3 branches of government, co-equal branches, and the founders chose to vest accountability for 2 of those branches in the electoral process. So lawmakers are elected, and the president, so too, is accountable to the people through the electoral process. By contrast, the framers placed accountability for Article 3 judges in a different place, and that is judges are intentionally not accountable to electoral politics or to the majority in a political sense. Instead, they're accountable to the Constitution and to the rules that bind the exercise of the Article 3 judicial power. And that includes limiting judgments to cases or controversies. It means adhering to the jurisdictional limits that bind courts. And it means understanding that with the power to issue binding rulings that in some cases control the actions of private parties and coordinate branches of government, with that power comes great responsibility to ensure that rulings are proper in scope and legality.
Thank you for answering my question. Now it's up to Senator Durbin, but before he takes over, Senator Hawley, you will take over for me now, please. Go ahead, Senator.